Questions and answers on Philippine banking law. What are banks? Banks shall refer to entities engaged in the lending of funds obtained in the form of deposits. What is the standard of diligence required of a bank with respect to deposit accounts? The diligence required of banks is more than that of a good father of a family. Banks are required to exercise the highest degree of diligence in its banking transactions. That is according to Bank of the Philippine Island versus Kiawit, January 16, 2019. But the same higher degree of diligence is not expected to be exerted by banks in commercial transactions that do not involve their fiduciary relationship with their depositors. That is according to the case Pauses Reyes versus Court of Appeals. What is the degree of diligence required of monetary board members, PSP officials, and banking employees? The degree of diligence required of monetary board members, BSP officials, and employees is now aligned with that required of public officers under Section 38 and 39 of the Revised Administrative Code of 1987. Previously, it was extraordinary, but this time it is based on they cannot be liable for acts done in the performance of their official duties unless there is a clear showing of bad faith, malice, or gross negligence. What are the restrictions on transactions of a bank with its directors, officers, stockholders, and their related interests, or DOSRI? No director or officers of any bank shall directly or indirectly for himself or as the representative or agent of others, A, borrow from such bank, B, become a guarantor, endorse, or be a surety for loans from such banks to others, and C, in any manner to be an obliger or incur any contractual liability with the bank. That is from the General Banking Law. What distinguishes a conservatorship and closure? A conservatorship is a tool in restoring the viability of a bank or a quasi-bank through measures to address its state of illiquidity, whereas bank closure involves forbidding the institution from doing further business in the Philippines, which may be summary process without need for prior hearing. When a bank undergoes a closure, is a hearing a requirement for the institution to be placed under receivership? The answer is no. Whenever the Monetary Board finds the existence of any of the grounds under Section 30, it may summarily and without need for prior hearing forbid the bank and quasi-bank from further doing business in the Philippines and place the institution under receivership. The same authority may also be exercised over non-stock savings and loan associations based on the same applicable grounds. The PDIC manages the affairs of a closed bank and preserves its asset for the benefit of the creditors. What are the roles of the PDIC when a bank is ordered closed and placed under receivership? When a bank is ordered closed and placed under the receivership, the PDIC is mandated to proceed with the takeover and liquidation of the closed bank. The PDIC shall immediately gather and take charge of all the assets and liabilities of the bank, administer the same for the benefit of its creditors, and exercise the general powers of a receiver under the revised rules of court and the PDIC charter. May a bank under receivership sue or be sued? The answer is no. Bank under receivership can only sue or be sued through its receiver, the Philippine Deposit Insurance Corporation or PDIC. Thus, a petition filed on behalf of a bank under receivership that is neither filed through nor authorized by PDIC must be dismissed for lack of jurisdiction. This is under the case of Bangko Filipino Savings and Mortgage Bank versus Bangko Sentral ng Pilipinas. What are the covered deposits under the bank secrecy law? Generally, The bank secrecy law provides that all deposits of whatever nature in banks or banking institutions in the Philippines and investment in government bonds are absolutely confidential in nature. The Philippine Deposit Insurance Corporation, or charter, provides for the definition of deposit and excluded investment products. Thus, investments in securities that are not government bonds are not covered by the confidentiality rule under the bank secrecy law. That's under Philippine Stock Exchange versus Secretary of Finance. Are trust deposits covered under the bank secrecy law? The answer is yes. The phrase of whatever nature in Republic Act 1405 prescribes any restrictive interpretation of deposits. Republic Act 1405 applies not only to money which is deposited, but also to those which are invested, such as those placed under a trust agreement. To hold that the trust account is not protected by RA 1405 would encourage private hoarding of funds that could otherwise be invested by banks in other ventures, and such is contrary to the policy behind the law. This is under the case of Ejercito versus Sandigan Bayan. Are all deposits covered under the bank secrecy law? The answer is no. Not all deposits are covered under the bank secrecy law. One exception under the Bank Secrecy Act is where the money deposited or invested is the subject matter of the litigation. The subject matter of the action should be deduced from the indictment, such as in criminal cases or complaint in civil cases, and not from the evidence sought to be admitted. This is under the case of the Real Bank versus Maningas. Now, foreign currency deposits are likewise not covered because they are governed by the Foreign Currency Deposit Act, otherwise known as Foreign Currency Deposit Act of the Philippines, RA 6426. What are the covered transactions under AMLA, or Anti-Money Laundering Act? These are a transaction in cash or other equivalent monetary instrument involving a total amount in excess of 500,000 within one banking day. Another one, transactions exceeding 1 million in case of dealers in precious metals and precious stones. Another one would be for casinos, including internet and ship-based casinos. A single casino cash transaction involving an amount in excess of 5 million or its equivalent in any other currency. And finally, for real estate developers and brokers, a single cash transaction involving an amount in excess of 7.5 million or its equivalent in any other currency. Now, what are considered suspicious transactions under the AMLA? Suspicious transactions are transactions which covered persons, regardless of the amount involved, where any of the following circumstances exist, like 1, there is no underlying legal or trade obligation, no purpose or economic justification. 2, the client is not properly identified. 3, the amount involved is not commensurate with the business or financial capacity of the client. 4, taking into account all known circumstances, it may be perceived that the client's transaction is structured in order to avoid being the subject of reporting requirements under the Act. 5th, any circumstance relating to the transaction which is observed to deviate from the profile of the client and or the client's past transaction with a covered person. 6, the transaction is in any way related to an unlawful activity or offense under this Act that is about to be, is being, or has been committed. And 7, any transaction that is similar or analogous to any of the foregoing. Does the AMLC have the authority to examine deposits? May it be done ex parte? And what are the exceptions? So the answer is yes, notwithstanding the provisions of RA 1405 as amended. The AMLC may inquire into or examine any particular deposit or investment, including related accounts with any banking institution or non-bank financial institution upon order of any competent court based on an ex parte application in cases of violations of the AMLA, when it has been established that there is probable cause that the deposits or investments, including related accounts involved, are related to an unlawful activity. So may AMLC inquire into or examine any deposit or investment with any banking institution or non-bank financial institution and their subsidiaries and affiliates without a court order? Yes, these are the cases involving any of the following unlawful activities which can be inquired into by AMLA without a court order. Number one, kidnapping for ransom under Article 267, Act number 3815, otherwise known as the Revised Penal Code. Under Republic Act 9165 or the Comprehensive Dangerous Drugs Act of 2002. Cases of hijacking and other violations under Republic Act 6235, destructive arson, murder as defined under the Revised Penal Code as amended, including those operations by terrorists against non-combatant persons and similar targets. And finally, felonies or offenses punishable under the penal laws of other countries, and terrorism and conspiracy to commit terrorism as defined under RA 9372. Are lawyers and accountants considered covered institutions or persons under the Anti-Money Laundering Act? The answer is no. The term covered persons shall exclude lawyers and accountants who are authorized to practice their profession in the Philippines and are engaged as independent, legal, or accounting professionals in relation to information concerning their clients, or where disclosure of information would compromise client confidences or the attorney-client relationship, provided that these lawyers and accountants are authorized to practice in the Philippines and shall continue to be subject to the provisions of the respective codes of conduct and professional responsibility or any of its amendment. However, lawyers and accountants who provide any of the following services are considered covered institutions or persons under AMLA, and these are those who are managing of client money, securities, and other assets, management of banks, savings, securities, or other assets, organization of contributions for the creation, operation, or management of companies, creation, operation, or management of juridical persons or arrangements, and buying and selling business entities. The IRR explicitly mentions that lawyers and accountants who engage in activities such as managing client money or securities, managing accounts, organizing contributions for company operations, and creating or managing juridical persons or arrangements are covered under the AMLA. This means they have obligations under the AMLA, such as reporting suspicious transactions and ensuring that they do not facilitate money laundering activities. Now, what are the grounds that allow an examination of a bank account under the Republic Act 1405 or the Secrecy of Bank Deposit Law? So the following cases are where the depositor consents in writing, in impeachment cases, when there is a court order in cases of bribery or dereliction of duty of public officials, and when the money invested or deposited is subject of litigation. So that's it. Thank you so much. If you learned so much from this YouTube video, please like and subscribe. Thank you so much.